is in Norway when they were drafting the model bilateral investment treaty, which was supposed to be negotiated between Norway and other countries where Norwegian companies were going to do business. The impact of the environmental NGOs pushed the government to include specific provisions for respect of the environment, for being a good citizen in terms of environmental protection, and for not violating specific environmental standards. Another example occurred here in the U.S. when the U.S. was negotiating the free trade agreement with Colombia and with Panama, among other countries. The involvement of the organized labor unions here in the U.S. required the U.S. to include provisions for respect of labor rights in the specific agreements. Labor rights in those countries along the same standards that eventually are applied in the U.S. So, as you can see, the involvement of the civil society can eventually have broader impact when it's conducted in the international arena. One area where the international approach can also provide a lot of use is in the area of preambles of these specific agreements. The preamble of the international agreements provide a possibility for eventual disputes to be solved in a way in accordance with the intention of the states that agreed to the specific treaties. The example that comes to my mind is one in the context of investment disputes. Specifically, a dispute between an investor called Salini versus the Kingdom of Morocco, which was taken to an arbitral tribunal, required the arbitral tribunal to determine what was the whole rationale of the Kingdom of Morocco when it entered into bilateral investment treaty. And the arbitral tribunal decided to look at the preamble of the ICSID Convention, the so-called International Center for Settlement of Investment Disputes Convention, to determine whether specific investments were supposed to be covered under the relevant treaty. And that tribunal looked at the preamble of the convention, and it found that in the preamble of the convention there was a reference to economic development. And it made an interpretation of what economic development meant, and it ended up saying that economic development was, of course, the rationale of why countries were entering into bilateral investment treaties and investment treaties in general. And it determined that for an investment to be protected, it needed to be consistent with economic development. Economic development meant job creation, transfer of technology, not incurring into corruption, not incurring into violation of human rights, and not incurring into damages to the environment. So through the preambles, eventually a broader context can be given to interpretation of specific provisions of the agreement. More importantly, the Vienna Convention on Interpretation of Treaties specifically provide that in cases of ambiguity or doubt on the interpretation of specific provisions of treaties, the preamble and the so-called travaux préparatoires or preparatory work can be considered for purposes of coming to the conclusion of what the states meant when they were negotiating the agreements. And of course, in the preamble, states can include different references, but what is important, even in the context of this political pendulum that I referred to, is that when states specifically mention that they are, although they are protecting investors or they are opening the country for foreign trade, they are doing that because the ultimate rationale is that they are doing that in order to provide well-being for their citizens. And in many instances, they make the strong reference to economic development, to which we can refer later on in the Q&A session. Through the international agreements, I have also seen, now that I refer to free trade agreements, specific provisions for procurement, through which opportunities can be created for local entrepreneurs. For example, specific provisions can state that companies or investors coming from the other signatory party are in principle supposed to enter into a procurement whereby a specific percentage of the purchases they make need to be conducted locally, and so on. So my conclusion, and I wanted to finish with this part, is that poverty, as you can see in many parts of the world, is something that is created by legal systems that are not dynamic, legal systems that are to a large extent stagnant, legal systems that do not recognize specific rights, and even if they recognize, those rights cannot be enforced. It's not to say, as I pointed out before, that we do not have to continue pushing local legal reforms, but local legal reforms can be complemented with international approaches such as the ones that I mentioned, through which consensus building can be created in a broader context, through which inclusion can be promoted, and through which opportunities can also be created. So with that, I conclude, and I'm looking to.
Are there any questions? In the back?
Thank you very much for the introduction. Actually, I agree with you that some laws in our countries, Africa, Latin America, are not fair enough and not considering many people suffer a lot. But sometimes, if we assume that these laws are not available, what we can do? So, what I want to say, that sometimes the laws are not fair, but the problem in our countries is not in the unfairness of the laws. The problem actually is in the process that these laws are not effective enough. These laws are not active enough. This is the problem from my point of view. I agree with you that these local laws must be complemented by international approach just to develop our countries. But if we cannot at least keep our laws, our local laws, in standards which approach the international standards, we will lose and we will suffer a lot, and more than we suffer. Thank you very much.
Yes, I agree with you. I think it's a very vast entrepreneur to use the legal mechanism in order to fight poverty. I think the local legal reform needs to take place, but even locally you need to do more than just the legal reform. You need to include people. You need to recognize their rights, to give them identity. In many parts of the world, people lack identity. They don't have ID, they are not recognized, there are no registration for specific people. So you need to start probably from there to give them identity, to incorporate them into the legal system, and of course the way to do that is through local legal mechanism. But then you need to educate them. Educate in the context of letting them know what are the rights, how they can use the rights, how they can take advantage of that. And that's not necessarily a legal reform job. It's much more, if you will, an educational or promotional work. Then you need to do capacity building. Institutions, in many places, institutions are not existent, or they are weak, or they are coming from a transition. So institutions are a very important player in this whole context, and they need to be strengthening, and people need to be trained in order to conduct those institutions. And then, of course, you need the international approach. Why you need that? Because this, among other things, we live in a global world, etc., and you have all the advantages that I mentioned in terms of civil society involvement and certain rights that you can create. But this instability that I mentioned in the local legal reforms, you don't face that in